Good morning, and thank you for joining us for another BVI Breakfast Forum. I am Elise Donovan for BVI Finance. Today, we discuss what does the recent European Court ruling on public registers mean for international finance centers and for British overseas territories. When we have these types of topics, we turn to an expert to break it down for us and tell us what it all means. Oliver Cooper is the policy lead at Charles Russell Speechlys, an international law firm based in London. He advises a range of clients on international regulatory matters, such as corporate transparency, information exchange, and the EU and OECD blacklisting processes. He acts as counsel to the IFC Forum, a trade body for intermediaries in the British overseas territories and crown dependencies that include several BVI Finance members among its membership. Away from his day job, Oliver has extensive experience in both the United Kingdom and European Union politics. And he is a politician, by the way. Oliver, thank you so much for joining us again for another BVI Finance Breakfast Forum. You're no stranger to this platform, and we thank you again for really taking the time. And we expect again to hear from you all the details that we need to know about with regard to this EU court ruling. Oliver, I invite you to go ahead and take over the mic.
Great. Thank you so much for everyone taking part this morning, to Elise and the whole BVI Finance team for inviting me. Again, I always get a warm reception, although when you open by saying he's a politician, usually the reception cools quite rapidly, quite a lot. I do want to talk about the technical details of this judgment, but to be honest, the jurisprudential background so it matters a lot less than really what's, I guess, happening next for BVI and for other centres like it. So I'll talk very briefly about international standards, what they are and, to be honest, what they're not, what AMLD5 did require before this judgment, what the judgment said and why, and then the impact on the EU and UK and the impact on IFCs and the British OTs like BVI. So first on international standards. So FATF is obviously the number one progenitor of those standards, and recommendation 24 of the FATF recommendations is the place where it describes beneficial ownership of companies. That right now requires only that jurisdictions have central registers of beneficial ownership that's accessible by law enforcement and tax authorities and exchanged internationally with those other tax authorities and law enforcement that require information from them. It allows countries to have an alternative mechanism to a central register, but it has to be equally effective. And importantly, there's no requirement for public access. That's not because there's been a lack of trying by some countries to make the FATF recommendations do that. The United Kingdom government and the European Commission have pushed for a long time for the recommendations to be changed to require public registers. But it's been resisted by a number of other countries, most notably, of course, the United States. And although the current executive secretary, the CEO effectively of FATF, is supportive of public registers being required by it, the last executive secretary, David Lewis, himself British, said that they were window dressing on politicians' CVs, hardly a ringing endorsement. There's a current consultation out for both recommendation 24 on UBOs of companies and recommendation 25 on UBOs of trusts and other legal arrangements. They're at different stages. Recommendation 24 has got guidance, about 50 pages long of draft guidance has been published as part of the latest round of consultation. And recommendation 25 is a step further back on trusts. But also it's worth looking at what that new recommendation 24 will look like in the guidance. And the proposed text says that in passing, amongst a 50-page document solely on recommendation 24, it has one paragraph about public registers. And it says that countries may consider facilitating public access in some circumstances, but if they do, they should consider limitations due to data protection, privacy, security, and so on. And FATF does recommend that instead of public access, jurisdictions base their access on legitimate interest. So those that can demonstrate a legitimate interest, which is not defined by FATF, would be able to be able to access it, but the public would not necessarily. So clearly FATF is not right now supported despite that pressure. And the other standard setter in international environment, the OECD, is even less supportive. They've clearly rebuffed and rebutted all attempts to make it a requirement. And in fact, in their 2011 document, Keeping It Safe, which is still their standard document advice to international tax authorities on the exchange of information on request, they state in very clearly in the third or fourth paragraph that taxpayers need to have confidence their information is not going to be disclosed intentionally or by accident. And without that, they're not going to comply with the international norms and requirements expected of them. So that candor, it being based on confidentiality and privacy, means that they are strongly opposed to the idea of public registers becoming a standard, although they will tolerate jurisdictions adopting them. So that is a clear departure from the 5th Anti-Money Laundering Directive. And I'll get on to what it said before the judgment first. AMLD5 was passed in 2018. It replaced, for those of you that are good at maths, it replaced AMLD4, which was passed in 2015. AMLD5 has two major requirements that are relevant to us. One is Article 30 regarding the UBO registers for companies, and Article 31 regarding trust. We put trust to one side because they weren't the subject of the judgment, although you might imagine they'll come on to that later on. But Article 30, as well as the whole of AMLD5, the entire rationale is law enforcement, and it states that specifically. We'll get on to why that's important later. Now, one thing that's worth noting, for those of you that don't come from an EU perspective or English law background, directives must be transposed into national law by countries themselves. They do not, at least directives of this sort, do not have direct effect and applicability, which means that they can't take effect unless they're implemented in domestic law. Again, that is relevant as we get later on through the ratio of the case. Now, in terms of the nuts and bolts, Article 30 provides for access by three groups of people. Law enforcement and tax authorities must have access to the registers without any restrictions or redactions. Obliged entities, i.e. those that have to conduct customary due diligence, are entitled to access if there are restrictions, with any restrictions that are applied by the member state. And the third point is the public must be able to access it, or did so until this judgment. Before AMLD5 and the amendment of the previous directive, that third point, Article 35, subparagraph C, said persons with a legitimate, or persons that can demonstrate a legitimate interest. That's still the language in Article 31 regarding trusts, but it was the language regarding companies before 2018. That's also key, because we will get onto, with that point C having been struck down by the Court of Justice of the EU, what remains is not persons with a legitimate interest. What remains is subparagraph B regarding obliged entities, which is a more restrictive group than that. And subject to that, I said that law enforcement and tax authorities have to have access to the information without restriction. But the other groups, the obliged entities, the public, or those with a legitimate interest, can have access, but subject to safeguards that member states are allowed to adopt. And the practice by which they adopted them it diverges depending on which those safeguards we're talking about. Article 35A says that member states may require online registration or may charge a fee. Now, in practice, the vast majority of EU member states require online registration, but make it free. But that's not required. Member states can charge for it in a way that, for example, the PSC register does not. And some do avail themselves of that option. The second point is regarding, I guess, the disclosure to the beneficial owner of who is accessing their information. Where online registration is required, then that information as to who accesses each individual file can be disclosed to the beneficial owner or to the company whose beneficial ownership information is being sought. That's not stated expressly in the body of the directive. It's stated in recital 31 of the preamble, but first, preambles do have legal status and standing in EU law in a way I'm not going to get into because it's incredibly tedious, but also the European Commission confirmed in its evidence that it gave to the court in this judgment. They stated expressly that jurisdictions, the member states are allowed to do that. So as a result, in some countries in the EU going forwards, although not right now, you will end up with beneficial owners getting an alert or notice when their information is being accessed. And the third safeguard that is worth noting, and the one that was the crux of the joint judgments in Luxembourg that we're talking about, was that member states may redact the information where there's a disproportionate risk of fraud, kidnapping, extortion, blackmail, harassment, intimidation, violence, or where the UBO is a minor. And of course, every single member state in the EU avails himself of that, just as every country around the world would in a similar circumstance, and that's not been affected. But, however, it has been at the cornerstone of this judgment, because this judgment fundamentally was brought for two reasons. Both the claims, so there are two claims, two joint cases that were referred to the Court of Justice of the European Union. They were joined together because the ratios of the claims were so similar, but they sought slightly different remedies. So one of the claims sought clarification as to what the exceptional circumstances in which redaction is allowed. So there was one of the beneficial owners of a property company was said to be at particularly high risk of blackmail or kidnapping because of his activities in certain countries. And therefore they sought clarification of when that information could be expected to be redacted. And the other claim sought not just clarification, but their preference to clarification was a strikeout of public access altogether. Both those claims are joined together because they fundamentally brought the claim on the same grounds of failure to comply with the European Charter of Fundamental Rights. Now, the Charter of Fundamental Rights is a litany of rights stated within the Treaty of Lisbon 2009. The two rights that were particularly egregiously breached according to the claimants, were Article 7 regarding the respect for private life and Article 8 regarding the protection of personal data. Now, those are two pretty fundamental rights within, particularly fundamental rights within the Charter of Fundamental Rights. But it is also worth noting, despite the use of the word private and the word personal, decades of jurisprudence and case law previously in the Court of Justice found that that does include business affairs as well. So anything conducted in the course of business or officialdom except in government office is considered to be private life and personal data. That's always been the case. That wasn't the matter disputed here. And therefore, as a result, any protections that must be afforded to someone for their enjoyment of private life or family life must also be afforded to them when it comes to their enjoyment of business affairs or operation of businesses. And the second principle that's really important to note is a core principle of EU law. It was derived from German law and then integrated into EU law under the International Handelsgesellschaft case in 1970. And that meant that the EU has no power to act when it acts disproportionately. Now, proportionality doesn't mean the thing it ordinarily means in everyday life when it comes to EU law. It means necessary to fulfill a legitimate objective. And the legitimate objective in question can't be any old one invented post facto. It needs to be the legitimate objective that was laid down in the legislation or at the time the legislation was tabled. And if the legislation, as in this case, in LMLD5's case, if it was about combating money laundering and it said that on the base of legislation, then you can't retrospectively say, well, actually, it's about increasing public confidence in measures or matters. And that's really key because that was one of the key arguments that the European Commission used. And both the claims conjoin those two arguments. They say that there was an intrusion into rights in the Charter of Fundamental Rights, Article 7 and 8, and it wasn't justified on the basis that any of those breaches, the infringements of the rights, were proportionate and justified by the sense of necessity. Now, the judgment found in favour of the more extreme, I suppose, call for remedy in striking down. And the reason they did, the ratio judgment is in front of you, I'm not going to read it out, but fundamentally they found there was a serious interference with fundamental rights regarding Article 7 and 8, and that those safeguards that I mentioned earlier, the right to have information redacted if you're at extreme risk, the protection in form of potentially requiring people accessing the register to register for it, to potentially pay for it, potentially be disclosed information about who's accessed their information. None of those safeguards was found to be sufficiently strong and protective enough to justify that serious interference with both Article 7 and Article 8 of the Charter. So the result, the entirety of Article 35C, the public access, was struck down on that basis. During the course of the litigation, which began on for 3 years, there have been various different arguments advanced publicly and in the formal litigation. The European Commission did try to argue those safeguards were strong. One of the counter arguments that meant the court was not particularly impressed by that is the fact the European Commission had itself ignored a number of pieces of legal advice that were given to it when the legislation was originally being passed in 2018. So when MLD5 was tabled and when it was being debated in the Council of the EU, that is to say, the collected heads of government or finance ministers in this case of the then 28 member states of the EU, they were presented legal arguments by both the EU's data protection supervisor that argued it was a fundamental interference with data protection laws. And the second piece of advice they got was from the chief legal counsel to the European Council, who, on a bit of a tangent, has got the best name in normative-determinism I've ever encountered. He is chief legal counsel to the EU, Hubert Legal, which means he's he's legal counsel. So the consequence, so he said it was unlawful because it was disproportionate, and he argued that therefore it should be withdrawn, but member states ignored it nonetheless. So when that advice was obviously retrospectively put to the Commission, to the European Court in recent weeks in the litigation, they found very clearly the Commission didn't have a leg to stand on and tried to argue that they thought it wasn't a breach of those rights. So as I said, the judgment found that it was not necessary and therefore not proportionate to achieve the objectives of combating money laundering. The directive itself stated the purpose was to combat money laundering, and it said, in fact, in one of the recitals in the preamble, it stated that public confidence was a byproduct but not the purpose, so that the Commission really dug its own grave on that particular front. And obviously argued that so long as there was access by law enforcement and tax authorities, and so long as there was the ability to conduct due diligence by obliged entities, then clearly access by the public was not necessary. And so as a result, the court distinguished between public access and obliged entities. As it happens, when it talks about the definition of legitimate interest, that terminology has been interpreted by most EU member states in the past as meaning journalists and NGOs. But with this judgment, it's clear that actually that only has to mean, at a maximum, obliged entities conducting due diligence themselves. Anything else, journalists and NGOs, are determined to be legitimate only by member states' own domestic decisions. They are not required by EU law. And in fact, the court goes as far as to say that potentially it should not be allowed of member states in transposing EU law. And the third point I want to make regarding the content of the judgment is the incongruity that now exists between Article 30 on UBO information for companies and Article 31 for UBO information on trusts. Because Article 31 was not struck down, it wasn't subject of this litigation at all. And Article 31 still provides for access by those that can demonstrate a legitimate interest. So as a result, that still stands, but the proportion, anything in Article 30 regarding companies has been struck down. So actually, as it happens right now, access is wider for trusts within EU law than it is for companies, which is obviously not something that had been envisaged in the past when this framework was passed in AMLD5 in 2018. But it is where we stand. I am expecting that to be remedied by the European Union through further legislation to tidy this up, to perhaps specify that the AMLD has a purpose beyond law enforcement, to specify that it has another legitimate purpose for which it might be necessary to facilitate public access. But until then, there is that incongruity and there is that blurring of what it means by legitimate interest. In fact, that blurring was argued by the Commission in the litigation. Their submissions to the court, the European Commission said that because they specifically didn't define legitimate interest and because they specifically allowed member states to define it themselves, then clearly it would be neater and tidier for them just to allow access to the entire public as a whole. And obviously that got very short shrift from the Court of Justice of the EU, which said that obviously directives having to be implemented by member states themselves and not having that direct effect or applicability in cases like this. It meant that member states were entitled to define it how they wanted, and the EU using the shortcut of using EU continent-wide legislation to define legitimate interests as public was an abuse of effectively the Commission's power. Now, what are the outcomes of that, both proximately and longer term? First, Article 35C has been struck down in its entirety. It has not been wound back in time to where it was before 2018. So I said that provision for access by those with a legitimate interest has also been scrapped. So access is now only required under EU law by tax authorities and law enforcement under 35A, and also those obliged entities conducting due diligence under 35B. But 35C, for intents and purposes that are relevant to us, no longer exists. There's no right of appeal. I know the number of people have thought maybe don't read too much into it, it might be appealed. This was a judgment of the Grand Chambre, that is to say the Supreme Court of the European Union's court system, and therefore it can't be appealed. What happens now is the reference, this was a reference under Article 267 of the Treaty on the Functioning of the European Union, to be technical. This reference gets handed back to the Luxembourgish courts, and Luxembourgish courts then enforce it by integrating the reference they've got, the judgment they got from the European Court of Justice, integrating that into their domestic judgment.
Sorry about that. We'll wait for Oliver to come back while he's working through his technical difficulties. What we've heard so far is quite interesting, based on what Oliver has outlined. He outlined the FATF recommendation 24, which does not require, as he said, a public register, but it requires a central register or alternative mechanism and, demonstrated legitimate interest. Oliver is back. So I was just keeping time until you got back. So welcome back.
I'm so sorry for that, Elise. This is the second presentation in a row where my broadband has shut down and you've lost me. But I'm going to try to get back to where I was and pick up from, I guess, the beginning of the discussion of the impact on EU member states and the UK. So regarding that, so as well as Luxembourg, which was proximately the respondent to the claims and had a judgment against it, Luxembourg's removed public access to its registers, but so has Ireland, Belgium, Germany, Netherlands, and Austria, for various different reasons. Austria and Germany were always going to revoke it for historical reasons, and the others for frankly commercially competitive reasons were going to revoke it. But fundamentally, one of the questions that other member states have posed is whether they're really bound by this judgment and have to adhere to this judgment. What's worth noting is two, I suppose, distinctions. So the first is the Court of Justice of the European Union is not some sort of European Supreme Court. It is the Supreme Court of the EU's own legal system, but it is not the Supreme Court of the member states within the EU. And so its jurisdiction only applies to the application of EU law. And the second point of distinction is the EU Charter of Fundamental Rights is not in any way, shape or form an EU Bill of Rights or European-wide Bill of Rights. It only applies to acts of the European Union or actions of the European Union bureaucracy, or to member states insofar as they are implementing EU law themselves in their acts. There was a case about a decade ago, France and Sweden, that did, as it happens, by coincidence, was about tax law, but fundamentally it was about EU constitutional law, in which some commentators thought that maybe Pandora's box was opened and that there was going to be a slew of the Court of Justice of the European Union hearing cases about purely domestic national measures rather than national measures where they were implementing EU law. But that turned out to be a misreading of the Franzen case. And since then, the court has been quite consistent in only interfering in actions of member states as opposed to EU institutions themselves when those member states have been implementing EU law. So the real test as to whether these public registers are now lawful is whether the public registers were implemented with the purpose to, or appearing to, transpose AMLD5. If they were transposing or appear to transpose AMLD5, then it is not lawful and it has been struck down. And if they weren't, then the European Court of Justice does not have any jurisdiction in those matters, and the EU Charter of Fundamental Rights does not even apply in the first instance to those matters. So as a consequence, it's possible the EU member states themselves could simply re-implement their registers effectively through the back door, and by legislating to repeal their current legislation that transposes and purports to transpose EU law, and introduce legislation that does not purport to do so, and actually they will claim is unrelated to EU law. It might be cheeky and it might look disingenuous, but the fact is that that would make all the difference in terms of righting the wrongs that were found in the Luxembourg business case judgments last month. But there might be other claims that were brought by different persons in different countries that make a difference. The first is this might have to percolate through the courts of the other 26 member states of the EU. Clearly, 6 countries have taken down their registers, so I think the other 5 are probably in the clear and can't be subject to claims about this. But let's say France, Spain, Italy, they've all kept their public registers accessible by the entire world, and they will be subject almost certainly to litigation in the coming weeks if they haven't been already. So that might end up with greater ratios and greater limitations on what AMLD5 can compel member states to do. The second area where there might end up being claims is through GDPR, the General Data Protection Regulation. As I stated earlier, the EU's data protection supervisor, who is effectively the guardian of that regulation and corpus of data protection rules, said that AMLD5 was unlawful 4 years ago. And it's very hard to see how they wouldn't argue the case now. Now that's important because, of course, not only does this judgment concern the Charter of Fundamental Rights, but there's another mechanism, GDPR, outside the Charter of Fundamental Rights that enshrines the very same principles, and that does apply to EU member states in EU member states' capacity in enacting national measures. So if the data protection supervisor does find that in retrospect he was correct and actually it is unlawful to require public access, then all member states would have to take down their public registers. The third area where there might be further claims of interest, and that there is a further claim of interest before the Court of Justice of the EU right now, is regarding Article 16 of the Charter of Fundamental Rights regarding freedom to conduct a business. A claim has been brought against the Luxembourg business registers on exactly that point, and that differs from Article 7 and 8 claims that the judgment last month was concerned, because the freedom to conduct a business does intersect with the freedom of establishment and freedom of movement that are parts of EU law. And therefore, as a result, if that were to be found to be a ratio for the striking down of AMLD5 public access, as well as the ones that have been found so far, then that would have to be complied with by EU member states, because it probably would indicate that the provisions, if adopted domestically, unilaterally, would be unlawful. And the last area where there could be litigation, but I want to have huge caveats around this, is the European Convention on Human Rights. So the European Convention on Human Rights is unrelated to the European Union. I've got a nice picture of its space age court in Strasbourg. Unrelated to the European Union, but it does follow the jurisprudence of the European Union quite closely. And the Convention on Human Rights is seen as being a slightly less expansive form of the same document. The Charter of Fundamental Rights takes the European Convention of Human Rights, which applies, of course, to countries as diverse as Turkey and Azerbaijan and Russia, and it takes them further. But fundamentally, the core principles at the heart of both documents are the same. So it's possible that because the Charter of Fundamental Rights prohibits public access, so might the European Convention on Human Rights. But the other caveat, that I want to add to that, as well as it not being part of the EU structure itself, is it is incredibly slow as a process. The European Court of Human Rights almost never issued interim measures. It happened to last week, the Polish government, but only because it thought that there was a risk of immediate and irreparable harm, which is the standard within the European Convention on Human Rights required to issue an interim measure. And therefore, as a result, there will not be a measure or an interim measure issued against public access. The consequence of which is that before any intervention of the European Convention on European Court of Human Rights, you would have to go through the entire process of litigation. And for reference, in the last month, there have been 15 cases from the European Court of Human Rights. None of them concluded within 4 years of the initial application to the court, so the initial claim being brought, and several of them took up to 12 years. The average was 7 years from the application being made to a ruling being made. So in the absence of interim measures, 7 years is clearly not a sufficiently fast turnaround this to be heard anytime soon. So I don't think a huge amount of store should be placed on the prospect of the European Court of Human Rights intervening on this. However, it's very likely there will be some sort of application to the European Court, if only because, for example, the UK and Switzerland are parties to the European Convention on Human Rights, but they're not affected by the EU Charter of Fundamental Rights, because of course neither is part of the European Union. So that's one of the reasons why the consequences for the UK will be relatively limited. The UK's own PSC register predates AMLD5. It doesn't purport to or appear to be a transposition of it. In fact, it diverged from it sufficiently that the UK was formally reprimanded by the EU for failing to transpose AMLD5 in terms of public access, until the UK said, this is bizarre, we implemented it several years before you did. But furthermore, the UK is not bound by the Court of Justice of the EU. It is by the European Court of Human Rights and the European Convention on Human Rights that the court enforces. So it might be that later litigation does affect the UK, but right now it has not. The other caveat is the UK government is politically incredibly strongly committed to public registers. If there is a ground zero for advocacy of public registers anywhere in the world, it's certainly not in those international institutions like the FATF and OECD. It's not even in Brussels, it is in London. The UK government is the chief cheerleader for public access, and it will take a lot more than a judgment on the other side of the channel for the UK government to change its course. In fact, it's stated that in legislation going through Parliament right now, we'll get on to later. But the UK is considering how it affects its other work. So whilst the UK was the chief cheerleader for public registers of UBOs of companies, it was reticent to have a public register of trust, which of course, as we will appreciate, are far more widespread in the UK, or in England and Wales in particular, than they are in continental Europe. So as a consequence, the UK government dragged its heels when it came to the creation of the UK Trust Registration Service under AMLD5's requirement for access to that register of trusts. And it might be they look at whether there need to be changes to the UK framework on trusts, but they won't be looking at companies. And the second area, and one that has far more relevance, I think, to BVI Nexus companies, is the registered overseas entities. That is subject to a piece of legislation, the Economic Crime and Corporate Transparency Bill, that's going through Parliament right now. The government has realised the register of overseas entities doesn't really achieve a huge amount right now. There are too many loopholes and flaws in it. But moreover, it is now potentially going to be affected by this judgment. And when they are putting this legislation on the same subject through the House of Commons and next month through the House of Lords, the government is considering quite closely how requirement for public access to the beneficial owner of particularly residential properties will be affected by this judgment, and whether any changes need to be made to it going forwards. So what are the consequences beyond that for the IFCs and British Overseas Territories? Well, the first is that there's no obvious immediate impact on the IFCs. The OTs and the CDs are not directly bound by the CJEU. Why would they, when the UK itself is not either? But the OTs and CDs are bound by the European Convention of Human Rights. It is applied to them under the UK's accession to the convention. BVI's got a particularly exceptional status. It's the only OT from which petitions can't be received by individuals. So it might be that there are difficulties in trying to have an application against in BVI, but fundamentally it shouldn't change things, because any application, any claim made in any country to which the ECHR applies will be able to be interpreted and enforced in BVI, the UK or elsewhere. So that's a bit of a footnote, that's a bit of a red herring to some people. So fundamentally, if that long litigation process is gone through and there is a judgment at the very end of that very long tunnel on the European Convention of Human Rights, it might be that it ends up binding the OTs and the CDs and preventing the creation of public registers in BVR or elsewhere. But I think the starting point for that should not be talking about legislation or litigation in future years, but rather legislation in past years. The UK Sanctioned Anti-Money Laundering Act was passed in 2018 and does purport to require public registers in the OTs. Actually, what it does do, rather than what it purports to do, is it required the government to lay before Parliament an order in Council that would compel the overseas territories to adopt publicly accessible registers. The order in Council being laid before Parliament involves that short phrase involves two very technical pieces of terminology. The first is order in Council, means delegated legislation. And the reason I've got His Majesty the King there is because orders in Council are part of the remaining part of the Crown prerogative that haven't been eroded over the centuries by Parliament, and therefore they can only do a very limited number of things. And it's unclear that an order in Council can do all the things, including overriding human rights legislation if there are concerns about that, overriding constitutional safeguards. It's unclear whether it can do that. So it's an interesting provision that the Act requires the UK government to execute. And the second is laid before Parliament, which is a term of art in Parliament, and it means something very specific. It means putting basically the order in Council in the libraries, the House of Commons and House of Lords. It does not mean tabling it on the floor of the House of Commons for an affirmative or negative resolution. It simply means making it available for inspection by the members of the House of Commons or House of Lords in their respective libraries. That should have been obvious to the parliamentarians that drafted the hostile amendment to the Sanctions and Anti-Money Laundering Act that ultimately purports to bind the OTs, but they've now admitted that they poorly drafted it and they've come back for another bite of the cherry. And they've waged this campaign for several years, but the latest battle in this war is a hostile amendment that was tabled late last month to the Economic Crime and Corporate Transparency Bill. Now, the Economic Crime and Corporate Transparency Bill is fundamentally about expanding the powers of UK Companies House. It does not really intersect with public registers in the sense of requiring them or not, because Companies House has always been public, nor did it originally relate at all to the overseas territories. But an amendment was tabled nonetheless by the Labour front bench and by Margaret Hodge, who secured the amendment in the Sanctions Anti-Money Laundering Act to bring forward the implementation of public registers in the overseas territories. That amendment stated that the OTs should have in place public registers by June 2023, so 6 months from now, an incredibly tight deadline if it had been passed. Now, fortunately, it was resisted by the government very wisely, but the grounds by which it was resisted was because the minister at the dispatch box, who himself actually, when he was a backbencher, was a strong advocate of public registers being forced on the OTs. The minister at the dispatch box said that there was no point in accepting that amendment because fundamentally the OTs would adopt public registers anyway by the end of 2023 because they'd made commitments along those lines. So if the amendment had succeeded, if the Labour front bench had got their way, then all it would do would bring forward the requirement for public registers by 6 months and at the same time burn a huge amount of goodwill with governments like BVI that are doing their best to legislate in a way that's compatible with international standards. Now, you will all be aware that BVI made a commitment in September 2020 regarding public registers. And they included a number of, in a very tightly worded, sensibly sensibly caveated statement, the BVI government stated that it would work towards public registers in line with international standards and best practices, and as implemented by EU member states by 23 in furtherance of AMLD5. Now, all of those words in that part I read out are absolutely key and may have been changed by this judgment. And this is really the crux of the matter. I open by talking about international standards and best practices. And despite the fact that FATF has been put under a huge amount of pressure by the UK and the European Commission to make public registers an international standard, it clearly isn't an international standard yet. And in fact, the proliferation of public registers that the EU and the UK had somewhat, I don't know, arrogantly assumed would become the standard outside the EU simply has not happened. Australia has recently put to consultation a proposal for public registers of companies' UBOs there, but they did the same 5 years ago and that came to nothing. It's been a change of government since then. It's now a Labour government in Australia, so it might be that they go forward with it. But other than that, public registers have had absolutely no momentum outside the EU and the UK. And of course, this judgment shows that momentum is in fact going the other way within Europe. So it hasn't become the international standard, it hasn't become best practice. And of course, it hasn't been implemented by EU member states in furtherance of AMLD5. Because now, AMLD5, with that provision, Article 35C having been struck down, AMLD5 does not require public registers. It legally cannot require public registers within the EU. And furthermore, it's certainly not been implemented by all EU member states, because 6 member states have, even if it's only precautionarily, taken down public access and seemingly awaiting further litigation guidance or amendments to domestic or EU-wide legislation. So that BVI commitment in 2020, which sensibly tied BVI's adoption of public registers to other countries and jurisdictions adopting registers itself, is now going to be significantly, potentially significantly changed by this judgment 3 weeks ago. I should note, by the way, all of the OTs and CDs but one made a similar tying of the standards that they want to adopt to implementation by EU member states of AMLD5. So BVI is far from alone in having caveated their commitment in that way. But I think one should be quite cautious about it. Perception in politics, perception really is reality. And the fact is that the statement made by the Minister, Kevin Hollerake, at the Dispatch Box 3 weeks ago, that said that there was no need to adopt the hostile amendment because the OTs were going to adopt public registers anyway by the end of next year. That statement was made after the judgment by the Court of Justice of the European Union. Now, it was made the day after, so it didn't leave a huge amount of time for the government to reflect and digest what the court had said. But clearly, it hasn't yet changed the government's position or perception that jurisdictions, BVI, but also the other OTs and CDs, had made a commitment to adopt those registers by the end of next year. And that certainly is this unspoken agreement across the political parties within Parliament. That might change. I'm certainly active on that subject. It might change going forwards so that there's a greater appreciation of the incongruity and incompatibility of this requirement made by the Parliament on the OTs with both domestic and international human rights law. But certainly the perception right now is that a commitment has been made. So it's going to require engagement by BVI government with the UK to make sure that it's understood that the commitment was rightly caveated, and that caveat means that it might need to be reviewed. The second is that whilst the government has a majority in the House of Commons, and it was a House of Commons committee stage where the government resisted that amendment by the Labour front bench, the government does not have a majority in the UK in the House of Lords. It hasn't done for a while. I don't think any government ever will again. And therefore, as a consequence, the House of Lords, when it looks at that economic crime bill in January, is expected to debate and agree some format of amendment that will force the issue. As it happens, of course, you'll be aware the House of Lords is only a revising and advisory chamber. If the House of Commons really wants to put its foot down and override it, it can do. And therefore, as a consequence, even if the House of Lords does come back and say that they want to pass this Labour amendment, the House of Commons can use the fact the government has a reasonably large majority right now, even if they don't appear to appreciate it. They can use their large majority to override the House of Lords. But I suppose that is only a short-term position. The Labour Party's position has been for a long time using primary legislation, using acts of Parliament, not just orders in Council, to try to change the framework internationally. The Labour Party is right now, depending on which pollster you look at, between 11 points and 25 points ahead in opinion polls in the UK. That clearly will tighten very significantly over the next 2 years. Governments are always behind by that sort of amount, even or potentially slightly less at this point in Parliament. But the Labour Party is going to make a big song and dance about this if the government does continue to resist and respect BVI's commitment, having not been as is currently perceived by people. But the EU judgment was really very strongly worded and related to fundamental rights that are enshrined not just in EU law, but also in UK law, in the BVI constitution, in the constitutions of all of the other OTs and CDs, in international humanitarian law, and so on. And the power of it should really not be underestimated. This was not a merely technical or procedural rejection or striking down of the provision. It could have done that. The Court of Justice could very easily have limited its rejection of AMLD5 to proportionality. As I said, the definition of proportionality within EU law is very different to the ordinary common usage of that term, but it didn't. It used the expansive rationale and ratio for striking down the AMLD5's provision, and it also used, in terms of the remedy, striking down a very extreme version of what was claimed by the claimants. So as a result, it should not be under the prospect of it influencing public, not necessarily public opinion, but political opinion within the UK should not be underestimated. And hopefully those parliamentarians will look at that judgment and think about whether what they're doing in the UK is lawful, particularly if they try to force it on other jurisdictions. So I guess just a few conclusions I'm going to throw to. It's about half an hour of Q&A if people have any questions or want to open up to a wide discussion about the impact on BVI. The first is the judgment is seismic and final. It should not be underestimated how significant this judgment is and how far the Court of Justice went. The Court of Justice very rarely goes beyond what it's asked to do by claimants. Why would it? It's not how courts ordinarily work. But in this case, it did, and the extraordinary nature of that should be considered and borne in mind. And as I said, it's final in the sense there's no appeal, there's no other judgment needs to be given on EU law, and there's no prospect of this judgment being rolled back on further consideration by the courts. There is that immediate impact on EU member states with 6 members taking it down. I am expecting far more than 6 to have to take down public access, even if there's not any further litigation that comes to fruition. It's clear that a number of other member states are going to receive claims, and the quantum of damage that could be awarded against them, given the millions of companies and potentially tens of thousands of vulnerable people being listed on these registers, that quantum would dwarf the company's registers' capacities to contest those claims or compensate. So as a consequence, I am expecting more countries to take down their registers. Some have resisted it, but more to come. But there is no immediate impact on the OTs, CDs, or the UK. Future litigation might bind the UK OTs and CDs. I think that should be considered as a possibility if we're looking at a longer term, several year strategy on this particular subject. But the fact is that it will take several years. So betting the house on that litigation coming to fruition, I think, is probably ill-advised. The commitments made by all the OTs but one are tied to AMLD5, and there's almost no appreciation of this within the UK. So insofar as the political dynamics, insofar as the demands for the implementation of AML, of the Sanctioned Anti-Money Laundering Act are concerned, there will continue to be public pressure. There will continue to be Guardian headlines, but those headlines should not distract from the legal reality, which is that it's been found to be unlawful and incompatible with EU human rights law, which is mirrored very closely in both BVI and the UK's own constitutions. And the last point, and I think this is really key as well, is going back to that FATF and OECD standards that I opened with. They've resisted making making their registers or requiring registers to be public. And this will very clearly halt attempts to change the FATF standards to make them public. There is that consultation that actually closed a few days ago on revising recommendation 24. That clearly is going nowhere near requiring public registers. And when it comes to further changes and further assessment of jurisdictions against those standards and against the OECD standards, it will be many years before they're able to change it. So that is a really tangible outcome of this, which means that international standards are not going to budge. And I'm going to hand over to people for Q&A. I'm not sure, Elise, if you want to compare this section.
Thank you, Oliver. That is quite a lot of information that you have educated us on in terms of what this means for the EU, what does it mean for the BVI and other overseas territories and crown dependencies. I'm going to jump right into questions, so start typing your questions in the Q&A section, and we have one already. I think there's one that asks, what will the impact be in the BVI? But I think Oliver covered that topic, so I'll just go on to the next question. It seems an obvious response from the OTs would be to amend their constitutions to enshrine the principles of the EU Charter contained in Articles 7 and 8, with amendments to remove any doubt which may exist based on EU case, including around legitimate interests. Do you see this as a possibility, and what barriers might OTs face in doing this?
That's a great point. I'm not directly au fait with the provisions that every OT and crown dependency have within their domestic constitutions. I know that BVI's constitution does preserve the right to data protection and privacy specifically, so it's a constitutional principle within BVI. I would say any attempt to, I guess, directly align it with language coming out of the EU case will probably be logistically difficult, because the BVI constitution and the constitutions of other OTs and CDs are handed down by London, under, formally speaking, by the UK government under Audit and Counsel themselves. And therefore, as a result, you'll be opening up a can of worms if you try to ask for it to be amended in response to that legislation. So I would respectfully suggest that BVI not look at that. It's not quite as straightforward, but it's a great suggestion. And regarding legitimate, the definition of legitimate interest, which has also been raised in the question. One, there's no commitment within the BVI commitments or others to have any access by those with legitimate interest as some sort of backstop to full public access. The commitments made by the crown dependencies does state that they would make it accessible by obliged entities conducting customer due diligence by the end of this calendar year. So the crown dependencies have all legislated or are legislating this week before in the session before Christmas. They are legislating to have access by obliged entities. But as I noted earlier, obliged entities and legitimate interest should be distinguished, because legitimate interest is not a technical term, not defined, and sometimes been misinterpreted as including journalists and NGOs when it doesn't need to.
Yeah, so just want to reiterate that point that you made, that journalists and NGOs are not considered to have legitimate interest.
So to be precise, they're not required to be under EU law. So some member states of the EU have interpreted it as including that. The European Parliament has stated in its reports on the subject that it expects legitimate interest to be interpreted by EU member states as including journalists and NGOs. But the European Parliament is, to be honest, the least important part of the European Union apparatus. There are three major institutions, the EU, and the European Parliament is the least important of them. The most important are the member states and the Commission. So their sort of interpretation is neither here nor there. The fact is that member states in the EU can interpret legitimate interest as they see fit, but this court judgment, so the Court of Justice of the European Union found last month that the only thing that's required and can be required is access by obliged entities. And those with legitimate interest being given access has to be a choice of member states through their domestic legislation, not EU law.
Okay. Thank you, Oliver. Great presentation. You mentioned momentum was in favor of privacy and data protection. What would be the next step to interfere with the EU's obsession with low tax jurisdictions?
I'm not sure if the objective should be to interfere with their obsession. I mean, if you go back to that sort of the tripartite structure of the EU, the Commission, the Council, and European Parliament, of those three, they all have three very different views of low tax jurisdictions. So the Parliament is very, very gung-ho in favour of putting low tax jurisdictions out of business. And that is not within the gift of the European Parliament, and particularly it's not in the gift of the European Parliament because direct taxation, including taxation of companies and individuals, is not in the power of the European Union. It's a competence reserved to member states. That means that initiatives on corporate taxation and personal income taxation can only be initiated by the Council. It can't be initiated by anywhere else. And the second thing is it needs to be agreed by the Council, which represents the 27 member states, unanimously. Any individual one country can veto it. So you may have seen that the EU agreed last night to implement within EU law the OECD agreement on the two-pillar approach to the digital economy, including global minimum tax. That was held up for most of the last year by Hungary and Poland at different times, playing a bit of a tag team, each vetoing at different meetings, the agreement being enshrined in EU law. So if one country opposes it, things can't happen. And so every decision made on direct tax, including on blacklisting, grey listing, etc., in the EU, has to be made unanimously. And the EU member states have got a diversity of opinions on the subject. Some of them see, they look at some jurisdictions, low tax jurisdictions outside the EU, and they think they're looking in the mirror. And sometimes they think they're looking at competitors. And so as a consequence, it's sometimes the case that they want those low tax jurisdictions in the EU want to export high standards around the world to places like BVI, because that means that countries within the EU can remain competitive. And some of them actually see the threat of forcing countries outside the EU to adopt their standards as meaning that you end up with higher standards within the EU applying to Luxembourg, Ireland, Estonia, etc. So the result, there is a split opinion within the Council, within member states of that. And those member states that are sceptical of pressure on low tax jurisdictions are the greatest foes of the Commission and the Parliament's obsession. It's not us that has to interfere. In terms of the next step, however, I think there is going to be a slew of litigation on this matter. There was a completely unrelated judgment of the Court of Justice of the EU about DAC 6 a week and a half later, after this Luxembourg business registers case. DAC 6, you'll recall, is about mandatory disclosure rules, particularly with regards to avoidance of CRS and use of low tax jurisdictions. And the Court of Justice found that it was unlawful to require those benefiting from legal professional privilege to have to disclose the existence of advice to anybody else. And that was interesting because once again, the Commission in that case tried to argue that there was a general interest in trying to make this the legal advice available to tax and law enforcement, and the court said no, it's not proportionate given the protections that exist in every domestic legal system for legal professional privilege. So as a consequence, I think that is another part to show the courts are rolling it back as well. But all these judgments took about 3 years to reach, so it might be there's just a bit of a lag before we get to the final judgments on it.
Okay, just to note that we're going to have a taxing times discussion early in the new year. We were going to have it, but we thought that this topic was more important or more pertinent for this time. So we rolled back that discussion. We're going to have another taxing times, and all of us is going to come back again to talk about the tax issues and the Pillar 1 and Pillar 2, et cetera, and what's happening with that. I'll move on to the next question. You have said that amending the Constitution would not likely be politically feasible as this process is controlled by the UK. Speaking as a politician, if the UK rejects such a move by an OT, do you think this might be seen as imposing imperialism by forcing OTs to violate recognized human rights for what the EU considers an illegitimate purpose? Oliver, before you answer that question, I am going to move on to the more relevant questions, because we do have a constitutional review process going on right now. And that question of the constitutionality and the constitutional relationship can be taken to the Constitutional Commission for further discussion. How can BOTs get certainty? Many clients will move if there's a real possibility of an open register, open being wider than tax law enforcement.
That's a great question. I think fundamentally there needs to be a commitment by the UK government being cognizant of all these factors that states its position more clearly. I mean, the discussion I had earlier regarding the UK politicians that sort of misunderstand the commitments that have been made and also misunderstand their own drafting of the Sanctioned Anti-Money Laundering Act. Both those misunderstandings have the potential to lead to disastrous mis legislation. And going back to the previous point, would it be seen as imposing imperialism? Not within the UK. Within the UK, that sort of part of the narrative does not exist. Most people, if it occurs to them, would think the British Overseas Territories should comply with at least basic things asked of them by the UK Parliament. As it happens, IFC Forum conducted an opinion poll, or rather a commissioned opinion, a respected opinion polling company in the UK, to conduct an opinion poll, which found that the majority of the public think that BVI and the other overseas territories, I didn't name BVI specifically, but the overseas territories should be able to legislate to regulate their own financial services sectors in a way that would they think would maximize jobs, investment, and growth. So clearly there is a perception amongst the public that might seem internally inconsistent, that it would be absolutely fine for the UK to legislate if really fundamental issues of opinion came up. And this subject, the overwhelming view of the majority of the public would be that the public registers are a good thing. With incongruously at the same time saying that the OTs should be able to legislate themselves. So whether it would be straightforward for the UK to force its will on the OTs, I know it wouldn't be uncontroversial, but whether it would be uncontroversial politically within the UK would depend on which of those impetuses sort of wins out, allowing the OTs to decide for themselves how things affect themselves, and simultaneously the concept that public registers are good. Sad to say, constitutional law is not an interest of many members of the great British public, so they don't really care about the procedural side too much.
Seems we have a lot of work to do in terms of educating the British public about the constitutional relationship between the UK and its overseas territories and what the UK can and cannot or should and should not do. I'm moving on to the next question. Given the comments you made on European GDPR being a key part of the recent court decision, and given that the UK has equivalent GDPR legislation, do you see an equivalent GDPR argument being effective in the UK courts in the future on this subject?
That's a great question as well. So formally speaking, GDPR did not play a role in this Luxembourg Business Registers case, but it might be the subject of future litigation, and that's where things will get interesting for individual member states. So the principle of data protection and right to privacy and personal data in the Charter of Fundamental Rights is actually separate, although of course it follows the same principles. So there will almost certainly be claims brought in most, if not all, national courts against a breach of their domestic implementation transition of GDPR. In the UK, it's a Data Protection Act and Data Protection Regulations. Elsewhere, they'll have different names for it. Will it be effective? Probably not against the UK PSC. And the reason for that is because an act of parliament obviously is supreme over domestic regulations. And the Small Business and Enterprise and Employment Act 2015, which was a piece of UK legislation that adopted, that introduced a public PSC register in the UK, that is an act of parliament and therefore trumps the general data protection regulations, which are not an act of parliament, a secondary legislation. So the consequence, I'm not expecting it to affect the UK's framework. What it might do is affect the UK's ability to force its framework on other jurisdictions, but that is almost one part removed from it. And clearly GDPR does not apply to, for example, auditing counsel. So the consequence, it would need to be an argument played out in UK courts that influences politicians who then, because of that, decide not to pick a fight with BVI or other OTs or CDs on this matter. But I'm not sure that it would be able to be litigated.
The next question, is the UK seriously going to consider changing current legislation? They have not even blushed about the book Butler or The World or being the London grad. Greater shame was being out of the World Cup.
I know I'm not entirely sure the defeat the other night to France was a great shame. The team played really well, but yeah, the UK government is under constant pressure from the political opposition and the press in the UK for its stance on money laundering and transparency. It's why the Register of Overseas Entities has come into effect faster in the UK than it has for any other country in the world's register of beneficial owners of UK real estate. I used to represent a part of, in my former life as a politician, I used to represent a part of London that had a large number of properties that were owned through overseas companies. And the amount of criticism that was leveled just by ordinary residents for the fact that they didn't know where the local pub or where their neighbour's house was owned and who was the ultimate beneficial owner was palpable. This was not an obsession just by the Guardian. It is something UK real estate does touch the national consciousness, as I know that of course land ownership does all over the world. So that sort of stuff obviously came about despite the fact that the UK and London has a reputational problem with regards to the presence of lots of overseas money of questionable origin. The UK government did respond fast to it and will, I think, continue to respond ahead of other countries to it. So the UK might be a soft touch in terms of some aspects of enforcement, but in terms of having legislation on the statute books, the UK is always going to be pretty much always going to be first in the world at adopting measures. So that's one of the reasons why this is the Economic Crime Corporate Transparency Bill currently going through Parliament is in fact the second economic crime bill this year. There's an Economic Crime Act that was passed earlier this year. This is the second bill after it. There's a constant drumbeat of parliamentary business around economic crime. And so there's a constant range of opportunities for hostile amendments like the one that was tabled to this bill going through Parliament right now, the constant range of possibilities to attach those like baubles to the Christmas tree. So I wouldn't say the UK is blasé about it. It just might be a bit inconsistent about exactly which principles it's enforcing and how it intersects with GDPR and similar.
Can you, I guess, go over the comments with regards to FATF and the OECD's position on public registers? I don't think you said they resisted or requiring it, but they certainly did not make it mandatory.
Yeah, happy to. So FATF got a large amount of, so the FATF's membership, I think it's 38 countries, 2/3 of them are EU member states. It overwhelmingly overlaps with the OECD membership, but it also includes, for example, full membership of FATF includes Singapore, Hong Kong, Malaysia, a couple of other IFCs, as well as OECD members. And then, of course, jurisdictions like the overseas territories are involved in FATF discussions indirectly through CFATF and through representations at plenary meetings. But the FATF membership is overwhelmingly EU member states or European countries. And therefore, as a consequence, the preponderance of views are that we've adopted public registers through AMLD5. Why would you not adopt it as a global standard? This is a forum that we dominate and we get to set the rules of because we fund it. Well, the EU, Japan, and the US fundamentally fund it. And therefore, as a result, we should be able to ask for public registers. And that case has been made for a number of years. It was made before AMLD5 was passed, and therefore before public registers were enacted within the EU. And I am fully expecting it to be continued to be pressed for after this judgment and after AMLD5's provision has been struck down. However, I'm also expecting it to be rebuffed. So FATF Secretariat has resisted those claims, the Secretariat being a permanent standing civil service of FATF as opposed to its members. They've resisted its call, particularly because those two other major funders of FATF and major economies in the world, in the industrialized world, other than the EU, Japan and the US, they don't want to have public registers, and they don't want them to be required. So that's why it's been resisted. The OECD is even more resistant to it, because the OECD is a bit more removed from its members in terms of formulating policy. It's more like a think tank rather than an international regulator. And their conclusion has been that their other projects, particularly on information exchange, would be jeopardized by public registers becoming a standard.
The next two questions are about challenging the PABO's decision. What happens if a company wants to appeal based on our clear proviso that we would go to PABOs when they become a EU standard? And the next question similarly asks, what happens if a BVI co decides to appeal based on the fact that PABOs will no longer be an EU standard?
It's a great question. I'm not familiar with BVI public administrative law, so I'm going to read across what I know about English public administrative law. The fact is that I think this commitment was a public but political commitment made by the then Premier in the House in 2020. It doesn't have the status of law. It might give rise to legitimate expectations that the standard and the caveats that are adopted would be adhered to. But clearly the adoption of public registers or not adoption would be the subject of primary legislation passed through the BVI legislature. As a result of that, I think any claims on public administrative law will fall by the wayside, presumably because primary legislation trumps legitimate expectations. But I wait for a BVI constitutional lawyer to tell me that I'm wrong on that. So I suspect that if BVI were to legislate for it, and that includes the UK legislating for BVI if the UK were to pass primary legislation on it, I don't think there would be any ability to bring a claim against BVI. But again, I stand corrected if anyone wants to correct me.
What about a claim in the UK?
I don't think it would be able to be brought on those grounds. because the decision maker has to be, if you're relying on the defense of unlawfulness because of legitimate expectations or irrationality because of legitimate expectations, then you have to be the same decision maker that gave rise to those expectations. So statements by the BVI government can't bind the UK government in public law terms. So I suspect the claim couldn't be brought on those grounds. What could potentially be argued, if the UK at any point needs to rely on necessity for any provision. So, for example, if the Information Commissioner, which is the regulator for the GDPR in the UK, if the Information Commissioner were to say that it cannot be required unless it's necessary, I think the BVI could then argue it's not necessary because the commitment was made that linked it to international standards and EU standards. But I'm spitballing to an extent. The fact is, any statement made at the dispatch box, no matter how carefully worded, is always going to struggle in becoming a factor in claims where there is primary legislation against it.
I don't think we have any more questions. So I think if there's anything else that anybody else has to ask, we'll just be here for another 5 minutes. Excellent presentation, lots of information. I think we are all educated about what this means for us as overseas territories and for international finance centers. Essentially, what you have said is that by and large, it has no bearing on the UK or its overseas territories. Am I summarizing correctly?
I think it's fair to say no direct impact on the UK and OTs, but fundamentally, if there were the political wiggle room in the UK to respect the commitment that was made by BVI in 2020, then it would be transformative, because the commitment very clearly ties it to applied standards in the EU under AMLD5. The question, therefore, remains, is that political will there? Is that openness to hear what was said rather than what people in UK Parliament maybe wanted to be said? Is that will and openness there to have a dialogue about it? Because very clearly, that momentum that seemed like it was all going in one direction, in terms of always requiring more and more public registers around the world, one, stalled about 2 years ago, about the time that the pandemic started, and no country has required public registers since then, and is now being reversed. So I think any statements, any legislation that was created in that world where it seemed like everything was going in the same direction and just accelerating, I think all those commitments and legislation should be reviewed in this new reality.
What does this unlevel playing field look like if we move ahead at the end of 2023?
That's a great question, and I think that does also depend on what happens elsewhere. So for many, many years, you would have said two things. One, that always and everywhere there's this movement outside the US towards public registers, and then within the US that it would never ever happen in a million years. And the US has not adopted public registers, but it has now adopted the FinCEN final rule was published a couple of months ago, implementing central federal register of beneficial ownership of companies. In the US, it's quite wide ranging. It requires registration of any entity that needs to be incorporated with a certification as Secretary of State at the state level needs to be on that register. So it's much more wide ranging than people had thought it might be. That has happened despite people always predicting that for privacy reasons, because of Article 4 of the Fourth Amendment, they thought that would never happen in the US. So those two expectations, that the US would never move towards transparency and the rest of the world would always move towards transparency, both of those predictions have been confounded. And therefore, to an extent, whether momentum can be regained by the advocates of public registers, the European Commission, the UK, and some NGOs, whether that momentum can be restored will greatly depend on whether this new normal ossifies the concept of central registers without public access, or, because that's where we've effectively landed, both the US and EU have unwittingly landed in roughly the same space, or whether it leads to a renewed conversation about which direction the world wants to take. Because we have to be honest that public opinion, basically the world over, is in favor of public access in almost all cases. And therefore, as a result, if it does increase in salience as an issue, then it's probably bad news for those of us that oppose public registers being a worldwide standard.
Okay, someone wants you to wear your political hat and say what happens if.
What happens if what?
I think it's related to the previous questions about the company deciding to appeal.
I think legally it gets nowhere, to be honest. I see there's another message saying should see us talk about next steps because the level playing field, the playing field now is unlevel. I'm not sure if that's the same person that was thinking that thought. If that's a direct question, CDOT should obviously be talking together, the OTs in particular, because they've got all the OTs of the same legislative gun pointed at them through the Sanctioned Anti-Money Laundering Act, or purporting to do so. The CDs are only not within the Sanctioned Anti-Money Laundering Act because there was a greater appreciation within Parliament, and particularly within the House of Lords, that the UK government simply cannot legislate for the Crown dependencies in any circumstance against their will, because they've never been part of the UK. So as a consequence, that's the only reason why they're exempt. But nonetheless, I think all should talk together about where this goes. All of them but one have made the same sort of attachment to the standards to AMLD5, so kind of possibly fallen by the wayside all at the same time. But all of it is very political as well. If the OTs and CDs look as though they are using this as an excuse to diverge from commitments the world thinks that they made, that is not going to sit particularly well. If it's used as a reason to do so, because there are now clearly drivers that mean it's not going to become an international standard, because the reality really has changed around the world in terms of setting what the standards are. If that is the logic that's used, then I think there is a prospect for a conjoined approach between all the OTs and CDs working together to move the needle. Clearly, however, it would be better for them to also, as well as having allies amongst themselves, having allies from outside that pack that can also make the argument, whether that be the US or Switzerland or EU member states that are unhappy with it becoming a global standard in light of this judgment. I think that argument should be made by as wide a coalition as possible.
What do you think will be the CD's position? Because you just said that the UK cannot make laws for them because they were never part of the UK technically. So what would be their next move, the Crown dependencies, because they're not in the same situation as the overseas territories?
I don't think it's fundamentally that different to the thought process in the overseas territories, except that gun that's pointed at them is not loaded. So it might seem sometimes like an empty threat, but clearly
I think Oliver is frozen again, but it's time for us to wrap up. I'm going to, in his absence, I think he's going to be back shortly, but in his absence, I want to thank you for taking the time to be a part of this very important discussion. I think Oliver did an excellent job. He's back. Good to have you back again. A really very excellent presentation. And we are very much pleased that you were able to join us. If you want to say anything, wrap up before we say goodbye.
No, thank you so much for all the great questions. And I look forward to seeing you at the Tax Insights talk on global minimum tax in the new year.
Okay, once again, thank you for joining us for this BVI Breakfast Forum. We thank Oliver Cooper, who again is such a resource, and we're pleased that he's always willing and ready to jump at the chance to help us when we ask him at BVI Finance. So we are pleased to have Oliver, not only as an expert, but as an honorary BVI Finance member. Thank you so much for joining us, and do have a pleasant day, and we'll see you next time with Oliver on the taxing times discussion early in January. Thank you, and do have a pleasant day.